Good afternoon and welcome to the Alternative Dispute Resolution Certification Working Group. Um, please remember throughout the meeting that it is being recorded. Karen, would you please take the roll?
Karen, you're muted.
I apologize. Nolan Armstrong, absent. Claudia Coulter,
Here.
Dana Curtis, absent. Stephen Dinkin, absent. Paul Dubois, absent. Jenna Ellis,
Here.
Dr. Getz, Higauchi,
Here.
Hodgson,
Here.
Kelly,
Here.
Hopaken,
Here.
Cruz absent. Lowe,
Here.
Judge Lucky, absent. Polivsky,
Here.
Judge Bichon,
Here.
Robertson, absent. Tuckman,
Here.
Welch,
Here.
Yamshan.
Here.
Thank you, Chair. We have quorum.
Thank you. Thank you very much, Karen. Next on the agenda is the call for public comment. State bar staff will attempt to call members of the public in the order that they appear in the attendee pool. Karen, would you please provide the instructions?
For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the committee, please click on the hand icon now and State Bar staff will call on you in the order the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. We will allow 3 minutes for each speaker. The on-screen will begin as soon as you start your comment, and you'll be verbally alerted once you have 30 seconds remaining.
Thank you very much.
Oh, Dana's here. Happy birthday.
Oh,
Yeah.
hi, thank you.
Happy birthday. Hi, Dana.
Does that mean I'll be forgiven for being late? It's my
Well,
birthday.
of course. Thank you for being here.
Yes, I can't imagine spending a better birthday than with all of you.
Oh, that's really nice. Um, Karen, are there any members of the public who wish to speak?
We do not have any public comments today,
Oh,
Chair.
all right. Thank you very much. All right, then we'll move to the approval of the minutes. It's the minutes from the August 5, 2026 open session. Are there any corrections or modifications? If none, may I have a motion and a second?
Also move. That's Kelly.
Thank you, Mr. Kelly.
I'll second.
Thank you, Ms. Coulter. And Karen, would you please take the roll?
Yes, Chair. Armstrong, Coulter,
Yes.
Curtis,
Here,
Dinkin, Dubois, Ellis,
yes.
Dr. Getz, Higauchi,
Yes.
Hodgson,
Yes.
Kelly,
Yes.
Hopaken,
Yes.
Cruz, Lowe,
Yes.
Judge Lucky, Polivsky,
Yes.
Robertson, Tuckman,
Yes.
Welch,
Yes.
Yamshan,
Yes.
Judge Bichon.
Yes.
Thank you. The minutes have been adopted.
Thank you, Karen. Next on the agenda is my report. I don't have any report today, but I would ask if you would please set your sights on getting through the remaining appendices on the agenda today. As you can see from the agenda, we did reserve 2 appendices for August 20, and that is supposed to be our last meeting. So if we can, it would be great if we could get through Appendix D, F, I, and J today. Thank you. Next on the agenda is the staff report. Ms. Mia Allen and Alan Weiner, does the staff have anything to report? And also Erica Doherty. Anything to report?
I do
Nothing for me.
not. Thank you.
All right, then we'll move on to the business session, and we'll start where we left off yesterday. That is with Appendix D and standard number 2, and I'm going to turn it over to staff.
Thank you, Judge Bashan. Just as a brief reminder for those who were here yesterday and or catch up for those who weren't. Yesterday, the working group began discussing the application of the ethical standards for mediators. And in this discussion, a working group member suggested that there be a change in the application or applicability section to align more with the application of the ethical standards for provider organizations. There was some discussion about that, and staff asked for time overnight to prepare some of the alternatives that were raised and to try and address some of these questions. So hopefully you're seeing my screen, and what I'm showing now, the first highlighted section is what the working group's tentative recommendation that was distributed for public comment was. And I've noted in this that there's a possibility that the staff may ultimately make this as an alternative staff recommendation to the Board of Trustees if the working group narrows its recommendation concerning the application. As I mentioned, there was a suggestion that the application provision be narrowed to be more aligned with the provider organization application. And that states, as I've put here, these ethical standards apply to ADR services administered by a certified provider organization when the ADR service is conducted in California or governed by California law. The working group had some discussion about, in particular, what it means for mediation to be conducted in California or governed by California law. The first question having to do with conducted in California, there were observations of the current, multi-state and international nature of mediations conducted by Zoom and otherwise with parties dispersed within and throughout the state. So staff tried to take that into account in preparing this alternative for your discussion, for your consideration, which is, we think, closely based on the provider organization. Just by way of introduction, so let me just quickly say, so it covers when the mediator or participant is located in California. That's sort of what we thought might be a sweet spot for what a mediation conducted in California could be. We also talked about pursuant to a written agreement that was entered or to be performed in California or that is governed by California law. Staff also noted that there are some provisions of the ethical standards that would seemingly need to have broader application than these 3 provisions set forth in A. So for example, A, in all of these cases, would refer to mediations that are being conducted by the certified mediator. One of the standards relates to marketing. And so if you limit the application of the standards to the mediator's obligations when conducting a mediation, it seems like that would make the marketing limitations superfluous. And so staff went through the standards and tried to identify some provisions that the working group might want to consider carving out. So with this optional provision, we've said, except as provided in B, the rules apply under these limited circumstances. And then B would set forth circumstances or identify standards that apply to a certified mediator at all times. So options that the working group might consider if you wish to make the standards in any way broader than as stated in A, would be compliance with confidentiality laws. And I can give more detail on each of these. I don't want to take too much of your time, but use of confidential information. I'll give information on some of them. So if a mediator receives confidential information, you might want to restrict them from using that confidential mediation outside of a mediation that's been conducted. So that might be sort of a global requirement, the restrictions on use of confidential. Compliance with qualifications. It talks about continuing to meet the qualification requirements for being a certified mediator or for being a mediator on any other plan. Truthful representation of background, somewhat related to marketing perhaps, informing the state bar of discipline and other matters, truthfulness in marketing, representations concerning state bar certification, refraining from promises, guarantees, or implications of favoritism, and compliance. This doesn't look right. Compensation and gifts, compliance with laws and rules. So presumably not accepting a gift outside of a mediation that would be precluded by the standards. So that's what we have to offer for your discussion as far as these general application sections, and happy to answer any questions.
Questions? Yes, Mr. Kelly?
Not really so much a question as I really appreciate staff's going through the whole thing and saying, here's where you might want to apply this, even when you're not conducting a mediation. This, just reading through it the first time, looks very good to me. And when it's appropriate, I'd like to move that we adopt the staff's optional paragraph B. I'd also just quickly like to comment on the record in response to one of the comments yesterday from the public comment. They said that it should be clear, excuse me, that the standards weren't intending to set up a new standard where mediators could be sued in civil court. I apologize. And I noted before it went by that is part of our standards already. So I just wanted to make that comment.
Okay, thank you, Mr. Kelly. Any other comments? Or questions?
I see Mr. Polewski's hand.
Yeah, I don't want to slow us down. I just have a grammatical question. Alan, would you take it up to the top for a second there? Could we just say these rules apply at all times during which a mediator is or was certified? You can leave it the way it is if you want.
Are you talking about in the first,
Yeah, right there.
the original tentative?
Rather than saying after decertification, while you were certified, just say is or was certified. But if you want it, you can leave it there. I just thought it would be simpler just to say it that way. But
yes, I was tasked to point out that we have sort of dispensed with the decertification provision, at least in these other variations that we're putting out for you. It seems like with this new definition, it would be clear that they applied when the certified mediator was conducting a mediation, or during the time they were certified. We thought that was superfluous, but I appreciate, Mr. Polewski, your suggestion
Alan,
to say
sorry, if I may, isn't that A going to be omitted though, if we adopt the alternative one language?
If the working group does adopt the alternative one language, then yes, it would be eliminated, although it might be become a staff alternative recommendation.
And then after A1.
But I'm not sure,
I'm
the
sorry.
working group hasn't yet decided, to my understanding, the working group is discussing whether to change the original tentative recommendation. But if it does decide to change it, then yes, it would not be a working group recommendation.
And then after A1, you should have an or, while the mediator down below or participant is located in California or pursuant.
Sorry, I'm struggling a little bit with getting my track changes to obey. Is that where you meant, Mr. Pilevsky?
Yeah, and if you make the change up above, you don't need the whole second part of the sentence, but you can, I don't need to get into the grammar part now.
So you would say, well, I'm not sure, Mr. Pilevsky, if you're foreshadowing that you might make a motion to go with the original
Not at all.
recommendation,
Not
or
at all. No,
in
not
which
at all.
case you would want to
I was
edit
just reading it.
or I see Miss Curtis's
Yes,
hand.
Ms. Curtis?
Oh, yes, just one minor typo in that line in case we use it, which is these rules apply at all times. And then what I wanted to do is just get clarification on whether located in, let's see, mediator or participant in the mediation is located in California. I'm not sure what that means. Does it mean during the mediation? Does it mean online, in person? Does business out of California? You probably discussed this, but and I apologize if I missed something, but I wasn't clear.
No, this was not on the screen yesterday for discussion. This is what staff asked for overnight to work on to present to the working group. So this is saying apply when a certified mediator conducts any part of a mediation while the mediator or participant is located in California. So I think that may
Okay, that helps.
address
Thank you.
your question,
Yeah.
Ms. Kurtz.
Okay.
And I see Mr. Yamshan's hand.
Yes, Mr.
Yeah.
Yamshan.
Thank you. Dana, part of this arose because there was concern because some mediators in California will be conducting mediation processes with parties and counsel completely out of state and applying other state law. So it can get a bit sticky. And I think what staff is trying to do is to clarify things as much as possible, which admittedly is quite difficult.
Well, thank you. And pointing out the preceding clause makes sense. Thank you.
Thank you. Mr. Tuckman?
Thank you, Chair. Is new paragraph A2 based on language that exists elsewhere? Or was that was an attempt to encompass?
Yeah, so
right?
Yeah, if I may. So there was discussion yesterday about whether there's a mediation clause. When I think when the group was talking about what's governed by California law, if there's a clause in an agreement that says the agreement is governed by California law, that's sort of the reason. Staff was trying to address that aspect of the discussion.
Okay.
But to answer your question directly, no, it's not. It was not taken from another document that working group has been developing.
I just wonder if the first part of number 2 needs to be there, pursuant to an agreement that was entered into. Whether an agreement was entered into California, again, I'm thinking about certain contracts that don't necessarily have any connection to California, but might have been entered into there. I think certainly if it's performed in California, we want to include it, but I'm not sure that entering into the agreement in California should necessarily trigger incorporation.
And I'm
Okay.
not sure whether to say, whether an agreement that was or is, but maybe saying neither covers
So
it.
pursuant to an agreement that was that is to be performed in California.
I see Ms. Kopeikin's hand.
Oh, yes, I was just making sure Mr. Tuckman was done. Ms. Kopeikin?
Yeah, thank you. I think following on what Mr. Tuckman's comments and the discussion he just had with Mr. Weiner, um, I wonder if it makes sense to just delete a sub 2 in the staff's proposal, because if you're talking about a mediation agreement that is to be governed by California law, that's already covered by 3. If you're talking about a mediation that's taking place in California or where the participants are in California, that's covered by 1. I'm not sure that maybe you do intend to, but the only thing that 2 covers that those 2 don't already capture would be agreements that may never have contemplated being subject to mediation here in California by a certified mediator. So I'm not sure what 2 adds that would be appropriately added. Maybe I'm just low blood sugar, but does that make sense?
It may have been a late night on staff's part. I mean, I think what I had in mind was, yes, during the discussion yesterday, I hypothesized a real estate contract, for example, that, the standard CAR forms call for a mediation, and, that's a California agreement. I guess I hadn't really thought through. So if you have a CAR agreement, first of all, it's probably to be performed in California, since it has to do with the property transaction. But if there were similar clause in another type of agreement, should the standards become operative, I mean, maybe it's not critical if there's an agreement that's supposed to be performed in California and it's not performed in California, and it's going to not govern. Well, first of all, it probably would be governed by California, or it might be governed by California law. I think your point is well made that perhaps 2 is superfluous.
Yeah, I just think that I can't think of anything that we are intending to cover. And first of all, I want to second what Mr. Kelly said, because staff going through this after our 3-hour meeting yesterday is absolutely a big lift. So thank you for doing that. I'm confused by what that adds, and I think it might be more appropriate so I would propose that we just delete that unless unless I'm missing something.
Yeah, so maybe a thought of why it might be helpful. There was some discussion yesterday about how do we know if a mediation is governed by California law, and I think maybe staff was thinking about some kind of a proxy for that if the mediation agreement was entered into or to be performed in California. Maybe that would signify that it was, at least those would be 2 circumstances in which it might be governed by California law. There could also be, I suppose, different choice of law provisions.
Yeah, I'm not sure if we're talking about the mediation agreement being entered into California law or some other agreement. But so it just interjects some doubt for me, but so that would be my suggestion.
Are there any other? Yes, Ms. Curtis.
Well, I just put up for a minute, but I'll say it. So it may be that I'm not quite understanding number 1, as I indicated before, but let's assume that the mediator's in Italy and decides to conduct the mediation in Italy, even though the mediator's place of business is in California. So the second clause, I think, does provide clarity in that situation. But that might be because I'm not understanding the full meaning of this clause.
Are there any other comments?
This is Jen Ellis hopping in on this. I just wanted to note that staff proposed a similar carve-out approach on the provider subgroup ethics standards, and a majority of the working group twice concluded that we shouldn't follow the carve-out approach. And I think reason being that I think just the scope of complaints to be presented to the state bar, including regarding mediations that are, conducted not under California law, totally separate from California law. So I think staff's optional paragraph B, I agree with Mr. Kelly and Ms. Copagan that this looks like it was a significant undertaking, but I don't necessarily agree with it and would not vote for it if that's the vote we put up. Thank you.
And Ms. Ellis, what would your position be? How would this read?
I would only keep A, the subparagraph A. I honestly am on the fence about whether it matters that the mediator is sitting on Zoom in California and working with mediation participants in 3 other states on a matter that's not governed by California law. And I think that that would be covered by A1. But otherwise, this generally reflects what we discussed yesterday. I don't really have a problem either way with subpart 2 or 3.
All right, so then, Ms. Ellis, your suggestion would be to keep A as it's written now and not keep B?
My proposal would be to modify A1 to strike out the mediator or, and then eliminate B. Yes.
So while a participant in the mediation is located in California, is that how it would read?
Yes. Which, I mean, I forget, I know in some places participant technically includes the mediator, so maybe this is a distinction without a difference in the end.
So if I may, we're going to be talking about participants and parties in those definitions, because there was also a question about modifying the definition of party. So I think they're participant in this current iteration of rules. Definition of participant excludes a mediator. I would just ask the question, how is the mediator to know? And this applies probably if the mediator, regardless of whether this stricken language is kept or retained, but how is a mediator to know whether a participant is participating from California or somewhere else?
The case administrator, if it is being assigned through a provider, will provide all that information. So, for example, if I have a case with a party in council in Florida, a party in Pennsylvania, represented by a New York law firm, I will be informed of that so I can do a conflicts check.
Sure. And then what about traveling? So let's suppose that you have a Florida participant who travels to California, or you have a California participant who is out of the state of California. I mean, it sort of suggests that it should perhaps be not where the participant is located when the mediation is conducted, but what their, residence or usual place of business is.
Well, that could be, that's not unreasonable, but I think a better criteria would be what kind of contact there is with California. Is it subject matter? Is it the location where the harm took place in a different kind of case? Is it where a contract is supposed to be performed? Things like that. I think that somehow seems more rational than the physical location of the participant, because you can have a California based individual with California residency doing business over in Reno, and is how relevant is the California residency if everything revolves any place from Reno eastward?
Sure. I see Mr. Pilevsky's hand, but
Mr.
also just want to,
Go ahead, Mr. Weiner, go ahead first.
no, I was just going to say with regard to Mr. Yamshan's astute comment, just thinking that the purpose of the California statute is probably to protect Californians. So it seems like that might be a consideration.
Right.
You could change located in California to resides in California as one possibility.
Resides in is going to require a definition.
And I think also raises the specter of it is it resides or has a place of business in, and that could raise overbreadth questions if you have, a large national company that has places of business in, in multiple states. But I sort of preempted Mr. Pilevsky's hand. Maybe he's going to enlighten this discussion.
Well, I'm not sure I understand Jenna's problem, because to me, if you had to identify where a mediation is taking place for purposes of California law, California bar, it's where the mediator is. So to me, that seems like the first and simplest definition of where the mediation is taking place in this digital age. If the mediator's in California, California law, and I mean, the California standards should apply. I'm not sure I see the problem with that.
Okay, so I'm going to have to get a straw poll and just see where we are, because we can keep working on this and then it'll be clock. I appreciate all the comments because they are all very thoughtful. So I'm just going to make this suggestion just to see where people are. Mr. Weiner, can you unstrike the word the mediator or in number 1? And then can you unstrike was entered into or, and just so I can see where people are. Okay. Now, as it's written here, how do people feel? We didn't get to B, but as far as A is concerned, is there anybody who would support that?
Just for clarification, Judge Bashan, you're asking, reserving the question about this,
Yes,
the stricken clause here.
right. Is there, I'll ask it another way. Is there objection to A as it's written now?
Looks good.
Okay. With with objection, that last question, I see 2 hands raised.
Oh, you do? Okay, I didn't see.
Mr. Tuckman and Ms. Ellis. But
Okay.
your question before that was who supported it. There were hands for that.
Oh, I'm sorry, I didn't
It's okay.
see. Okay, either way, is there support for A as written? And let me find because I'm not seeing hands.
I see 3 hands. Let's see.
Okay, so
No, wait. No, there's more coming. I see 5. No.
I see Mr. Kelly, Mr. Pilevsky, Dr. Getz, Mr. Yamshan, Ms. Coulter, Ms. Curtis, Ms. Kopeikin, Ms. Hodgson, Mr. Welsh.
Would that
That would be everybody that I'm seeing on screen except for Mr. Tuckman, Ms. Ellis, Ms. Lowe, and Ms. Higuchi. So it would be more people who are agreeing with it than are not raising their hands.
okay? And the people who are not raising their hands, would oppose A as it's written? Okay,
Yeah, right. Yeah, just for the reasons that I mentioned previously. That's correct.
okay. And Mr. Tuckman, would you just state where you would change it again?
Yeah, I had suggested previously that my initial issue was just, I think there's ambiguity about the language that the agreement was entered into. This is number 2.
Uh-huh. And is it
Ms.
just those?
Kapikin also made the point about, maybe to be performed in California was also not necessary. I thought the entering into language was just a little bit more concerning to me.
Okay. So entered into or to be performed. Entered into, yes, that could require some clarification in the future down the line. If we take those words out, can I ask how many would support A?
I'm sorry, Madam Chair, you were cut off. I'm not sure what
Oh,
you're asking.
I'm asking, without was entered into, it with those words removed, is how many would support A?
Oh,
Okay, so I see Ms. Kopakin, Ms. Coulter, Dr. Getz, Ms. Lowe, Mr. Yamshan.
It's a couple of more than before, Your Honor, Judge Pichon. So
Okay, would
it's
that be,
majority,
is it the majority?
yes,
Okay,
One
with
question, if I
the
can.
exception of Mr. Kelly.
I was just going to ask Mr. Kelly, I believe you were supporting it before and you're not supporting it now with the deletion. Is that, am I understanding that correctly?
That's correct. I think it's a good thing to have in there, but I respect Mr. Tuckman's judgment, so I certainly wouldn't oppose taking it out. I just wouldn't support it without it.
okay,
What's the question? Thank
that's
you.
fair. That's fair. Okay, so that would give us the majority. If it's written like this, we would have the support of the majority on it. All right. So then let's look at B.
I'm sorry, Judge, you're inaudible?
Oh my gosh. Can you hear me now?
Hear you now.
Yes.
Yes.
Okay.
I
All
see
right.
Ms. Curtis's hand, and I'm not sure
Oh,
whether
that's
that's
a,
or
that's a mistake.
Okay.
Sorry.
So how about B? How many people would support B as written? Let's see. I think I saw Mr. Kelly's hand. And I think that's the only hand I see.
Yes.
Okay. All right. Um, I know it was a lot of work for staff to have done this. So is it the consensus then that I'm sorry, Mr. Uh, Weiner, can you scroll down a little bit so I can down the other way?
to CP? Oh,
Yeah, yeah. Okay. So then alternative number 1, I'm sorry. Under alternative number 1, we would keep everything including A as written now, except that those words would come out, except as provided in B. Now, can everybody support that alternative 1 minus the optional paragraph B?
Judge Pichon,
Yes.
could I ask, I'm curious about whether it's a desire to eliminate all of the exceptions in B, or whether there might be particular ones that are of concern.
Sure. Are there particular ones in B that are a concern, or just you would prefer that B come out?
I see Mr. Kelly's hand raised.
Mr. Kelly?
The reason that I said that I would support a motion when it was appropriate to include this is because unless I'm misunderstanding the point, there are certain standards that should apply all the time, whether or not a mediator conducts a mediation in California or doesn't. And I'd appreciate Mr. Weiner explaining why he took the time to go through all the standards and see which ones he believed, staff believed, should apply at all times. What's the point of this? It seemed to me like a very good addition, but apparently I'm the only one who thinks so.
Well, I'll ask again with that statement, Mr. Kelly. Is there anyone besides Mr. Kelly who would support the inclusion of subsection B? And I don't see any hands.
Mr. Pileski's hand is up.
I think that this is a great idea, but it seems like we're including more. And that this maybe should go first. I mean, it's almost as though we're including everything that matters. It may be easier just to exclude those that don't apply. But I'm happy with including these across the board as it's written. But it seems like it's almost inconsistent with, the limitations above. That's all, but I'm fine with it.
Okay.
If I can just explain or just respond to Mr. Pilevsky, there are a lot of provisions that would not be included, so this is maybe 10% of the paragraphs of the
Okay.
standards. And
Then
to
I'm good.
Mr. Kelly's question, staff thought the working group should consider including them in all kinds of cases, in all circumstances, because some don't seem to be related to a pending mediation. They're more general, like how to market services.
Okay, I'm good.
Okay. So has anyone changed their minds? The consensus is with a straw vote that B will not be included.
We have two raised hands.
Okay.
Judge Pichon, Ms. Curtis, and Ms. Kopikin.
Okay. Ms. Curtis?
Yes, I would like to, I'm assuming that Ms. Ellis and her colleagues on the working group that was related to provider organizations were not in favor of these carve-outs because they overly complicate things. I'm not sure what the objection was, but I'd like to understand that before I vote.
I'm happy to just share a little bit more, but Ms. Kopikin, I don't want to jump in front of you.
All right. We'll come back to you then, Ms. Ellis. Ms. Kopakin?
Yeah, I think actually that Miss Ellis is probably gonna, I'll leave that. That was one of my questions as to the reasons. I agree in theory with what Mr. Kelly said. I like the idea of us saying, look, if you're going to be certified, you should be following these, ethical standards in all places. But I'm mindful that there are many of us who practice and outside, many of us in the larger community who practice in various jurisdictions. This could become very complicated. I also know there's a drive to create nationwide certification, and these things could end up conflicting with each other. It's already going to be complicated if that happens. So I suspect Ms. Ellis is going to have a more articulate, having thought through this in her subgroup. But I think that I just wanted to bridge the gap between those two thoughts for what that's
Okay.
worth.
Thank you, Ms. Kopikin. I'll just say from the jump that this is the first time I've had a chance to look at this list, and I think that's the same for other working group members. And so I that does make me a little hesitant without having to go the opportunity to go through and study each of these provisions. And the reason particularly, and this we discussed this in the context of the provider subgroup and with the working group as a whole, but the main concern that has always been on my mind has been stepping on the toes of other jurisdictions and the obligations applying to mediators there, and just as one example, I'd want to go back and look at the standard 5 confidentiality here and check them out, because I know that confidentiality obligations range state to state for mediators. So it's for the primary reason here for me is simplification, I think, to Ms. Kopikin's point.
Okay. All right. Thank you.
Thank you.
So that puts us back with the support for A without support for B. So is that the consensus of the group? I did ask before, but I'll just to be sure, I'll ask again. The position of the group, how many favor alternative one, including A, but not including B? And I'll ask for a show of hands. Okay, see Mr. Tuckman, Miss Ellis, Miss Kopakin, Mr. Iguchi, Miss Lowe, Ms. Coulter, Mr. Yamshan, Mr. Welch. Did I get everybody?
Your Honor, Sarah Hodson also.
Thank you. Okay. And did I get everyone? And I believe that is the majority.
Yes. Yes,
Okay.
it is.
All right. Then that's how that standard would read. Very
Yep.
top.
Can I raise one question or issue, Judge Pichon, just for consistency for State Bar rules? That first "or" that was added, we don't usually add that there. So I would strike that because we have the second one.
I
Is
just
there any?
wanted to flag too that from our discussion yesterday, the existing B, if Mr. Weiner, if you wouldn't mind scrolling down past, I understood here application to certified firms that was also going to be adjusted in line with the working group's consensus on A. But I don't know if other folks have a different recollection.
I think you could make an easy fix to that.
Is that Miss Doherty?
Yeah, sorry.
Oh, okay.
I think you could just put as at the end, you could put as defined in section A. It'd be subparagraph A.
Thanks, Ms. Doherty. I see Mr. Yamshan has a hand raised.
Yes, Mr. Yamshan.
In regards to the or that Ms. Ellis has raised, I think it was farther up. We had a discussion yesterday regarding whether that should be in the conjunctive rather than the disjunctive. And I think the group decided that the disjunctive was appropriate. So because if with the conjunctive 1 and 2 would be a two-pronged test, and the consensus, as I recall, was that they could stand alone. So I'm not sure why or is not appropriate.
If I may, Mr. Yamcha, I think Ms. Mia Ellis's point was that by having the "or" here after the second one, it makes 1, 2, or 3 all disjunctive, that the State Bar rules don't ordinarily state it after each provision. So if it said "and," then you would need both. If this said "and" here, you would need 1 and 2 or 3.
Right, and the consensus was not to make it a two-pronged test and to continue
right.
disjunctive.
And I think Ms. Mia Ellis's point is that not having the "or" makes all 3 of them disjunctive under the State Bar rule drafting principles.
Yes.
I see. Okay, thank you.
Okay.
Okay. All right. So I think that let's see. We're good now. With A. And now with B, is there Any objection to the way B reads at this time? I'm going to ask for a show of, let me say that right. May I see a show of hands for those who support subsection B as it is written? No one supports
Lots of
B?
hands.
No, we see hands.
Oh, okay. Whoa.
All hands.
It's the majority.
Okay. Great. All right, then we'll move on from B, and that will take us to standard 3.
So if I may, staff is suggesting a technical revision here to say mediator and certified mediator mean a neutral person who is certified. It used to say just mediator, but because certified mediator is referred to above for the definitions, staff thought it would be best to also include certified mediator within the definition. The definition that was tentatively approved by the working group also said that mediator and certified mediator may be used interchangeably. So I guess the question staff has is whether the working group considers that a technical revision that's agreeable to you, or has concerns about it.
All right, for standard 3 definitions, subsection B, may I have a show of hands of those who support this modification of B, which is to add mediator, well, mediators there, and certified mediator? May I have a show of hands to those that agree? Okay, please tell me if I have a majority.
You have a majority.
Okay, wonderful. All right. Definitions also includes the C and D, that's participant and party. And I'm going to turn that back over to Mr. Weiner.
Thank you, Judge Pashon. So during the working group meeting yesterday, there were concerns about the definition of party, meaning individual, entity, or group taking part of the mediation. Particularly the concern was with the language that is asserting a claim or against whom a claim is being asserted. And it was noted that there may be people who are regarded as parties who don't fall within that definition. I had just made the note of a possibility of who has a direct interest in the subject of the mediation. But then I also, it occurred to me when the group was talking yesterday that there are multiple places where where party and participant are used differently throughout the proposed standards. And so I thought that if the group is making a change to this definition, I'm just going to take out what was my, playing with the words here. If the group changes the definition significantly, that could affect the operation of different obligations of a mediator. It could expand the mediator's ethical obligations under the standards, or it could contract them in some circumstances. If are used.
Alan, you're breaking up.
Sorry, can you hear me now?
Yes.
Okay, I'm not sure where I lost audio, but what I was saying was I suggested that the working group members look at how party is used with respect to mediators' obligations, before changing the definition of party, because you might be inadvertently or unintentionally changing the mediator's obligations in significant ways. And so I believe it was yesterday evening, I sent out a table, rather a chart that highlighted where party and participant are used in each of the throughout the standards. And so I'm not sure if anyone had a chance to look at that, whether you'd like me to put it on screen now, or whether you have other thoughts about whether you want to change the definition of party. I also want to mention, I'm pretty sure, not 100% sure, but I strongly suspect that this definition was taken verbatim from the rule definitions in the rules of court, which these ethical standards were very closely based upon.
Thank you. Mr. Palevsky?
I'm sorry, my hand was left up, but I thought
Oh.
the issue was that the claim was the problem, right? That not everyone in a mediation is asserting a claim.
Yes, the impetus was that the definition of party does not capture the nature of family law or
Right.
other types of mediated matters. That's what started this.
Right.
Anyone else? Let's see, I saw another hand, I believe.
I see Mr. Kelly and Mr. Tuckman.
Okay, Mr. Kelly?
If the language is going to be added, I think it needs to be added at the end of the asserting a claim or against whom a claim is being asserted. Otherwise, it might be conjunctive, someone who has an interest and is asserting a claim, just in terms of where it would be put. I'm afraid I don't see anything in my email that Mr. Weiner is referring to about the list of every other place that might be affected. So I'd certainly like to see at least a quick list of those up on the screen, because I don't find them in my email.
All
Thank
right.
you.
Mr. Tuckman?
I just want to say, I think this is a legitimate concern. I think the definition needs to be expanded beyond people who are asserting a claim or having one asserted against them. I think the arguments of the family people who do business partnership dissolutions, etc., there's been no claim asserted by either. And I do think it's an important definition. Thank you.
Can I just ask whether anybody else has seen the list or table I referred to? Or do I need to, you have, Mr. Welch, seen it? You did receive it?
I received it.
So did I.
I can still, I will find it and put it on screen. Nevertheless, I just wanted to make sure.
Mr. Weiner, you're looking forward to share your
Yeah,
screen?
I have it now. I'm just going to switch my screen share when this hopefully opens soon.
I'm sorry, Mr. Weiner, I did now just find it. Thank you.
Sure. In any case, it is on screen now. And so what staff did, I know this is small print, but went through the proposed ethical standards and did a word search for party and participant. Wherever participant is used, which is maybe less pertinent than party, because party is what you're talking about changing. But the column on the right shows all of the instances where party is used. Some paragraphs use both participants and party. So for example, party is defined as any individual, well, this is the provision we're looking at, asserting a claim or against whom a claim is being asserted. Participant means any individual, entity, or group other than the mediator taking part, including but not limited to the parties and the attorneys for the parties. So my thought was that if you change the definition of party from what you had and what was in the court rules, you may want to think about what implications that would have for some of these operative provisions. Would they change? Would they be broadened or narrowed by changing the definition? And if they would be broadened or narrowed, is that something that you would want to happen? It may be helpful to first think about how the group might want to change the definition, and then to look at whether that change would, how that change would affect the mediator's obligations, if at all. I mean, I think if it's a small change to the definition, my concern may be minimal or unfounded.
Thank you, Mr. Weiner. Let me just ask this question. With the definition as it currently is, if the mediation involves a family law matter, would there be a misunderstanding as to who the parties are using this definition? If there would not be a misunderstanding of who's referred to, then the subgroup that developed this based on rule of court or whatever they did had justification for using a simple version of definition of party. If this is not understandable, then we should change it. But if we can understand what's meant and it doesn't cause any confusion, I don't know that we should spend the amount of time we're going to need to spend to come up with a definition of party. Ms. Curtis.
Yeah, I'm not a family lawyer, although I've worked in family cases in the past, but there is a petitioner and there is a respondent in a family matter. So I think that that does fit within this definition of having claims asserted against one.
Thank you, Ms. Curtis. And that is a point that I had neglected to state, that there is a petitioner and there's a respondent. And I'm not sure that there would be any misunderstanding of what's meant here in the definition. Mr. Tuckman?
Thank you. Does it help resolve the problem by just saying in the definition, taking part in mediation that is asserting a claim or potential claim against whom? Something like that. I'm sensitive to the family law issue. And actually, I should say this memo very effectively, I think, makes the point that we're playing with fire when we mess with these definitions. But I'm just thinking maybe it seems like everybody recognizes a problem with certain types of mediations where claims are not being asserted in the way that we think about in litigation context, active litigation context usually. Does that help? Does that move the needle at all? Claims or potential claims?
It's still using the word claim.
Yeah, I guess I'm thinking that in the scenarios we've talked about, that we've discussed, that well, if you've got visitation, I suppose that language still doesn't work. Okay. It was just one thought.
No, that's great. Thank you. Mr. Kelly?
Well, I like Mr. Tuckman's suggestion, but I am sensitive to all of the work that Mr. Weiner did to put through an analysis of, are you sure you want to change all these other things, and do you want to examine it? And your point, I guess I'd just like to throw it open to the group. We do hope to cover pre-filing mediations, where there's no petitioner, there's no claim filed. Does this language sufficiently cover it so everybody knows that's what we intend? Is to also include things that are done pre-filing. Thank you.
Thank you. Anyone else? Okay, so Mr. Weiner, I just feel bad because you've done so much work on this, and I'm just gonna have to ask the group, do you want to leave the definition of party as it is, um, as it's written? I'll ask for a show of hands. Does anyone, based on all of the discussion, want to change the definition of party? May I have a show of hands? Anyone who wants to change that definition? Okay. All right. Then there's also the word participant. Um, does anyone, ask for a show of hands, want to change the definition of participant from what was originally written? Okay. That takes us to standard 4. Okay. All right. So standard 4 is voluntary participation and self-determination. The comments were, the narrative comments were, where the rules require the mediator to inform the parties of certain things at or before the outset of the mediation session, the first mediation session, they should clarify that this may be done in writing or orally. If it is done in writing, it could be included in the mediation confidentiality agreement. The next one, the current statutory and implementation structure should be revised before it hardens into a statewide framework that narrows a party's choice, marginalizes solo and non-lawyer mediators, increases costs for neutrals or disputants, and shifts mediation away from self-determination toward institutional conformity. Paragraph 4C specifically obligates the mediator to refrain from coercing any party to make a decision. This is an unnecessary restatement of the obligation already and included in paragraph 8B. And the last one, unnecessary to have to tell people that it is a voluntary process. Having to explain all of these things to participants is onerous and unnecessary. Would anyone like to make any changes to standard 4 voluntary participation and self-determination?
Alan, I wonder if you could share your screen.
Oh,
Or-
sorry, I thought I had switched back to that. My apologies.
Thank you. Thank you.
Would anyone like to make any changes? Okay, I'm looking, I don't see any hands. Okay, then we'll move on to standard 5, and that's confidentiality. Believe it or not, there's not a lot for me to read to you regarding that. The narrative comments included, the committee should include guidance on the use of AI and how it may breach confidentiality, privilege, etc. Another is, we should not have to explain confidentiality at the beginning of a mediation. I'm also concerned about breaching confidentiality if a complaint is filed. Some people can file claims with no basis. So I'm asking the group, are there any changes that you would like to make to standard 5 confidentiality?
Alan, could you just go back up a little? Oh, no, never mind. You're
Yes,
there.
I'm trying to make
Yeah.
this
No, you're
show
good.
more on the screen. Just give me a minute, please.
I see Mr. Kelly's hand raised, Judge Pichon.
Yes, Mr. Kelly.
Thank you. I have two quite different comments. The first is that Mr. Weiner, some 20 years ago, put together the most eloquent, short description of California mediation law that I've ever seen. I've been striving to get it into statute for all that time. It did go into statute as part of the safe harbor language that an attorney is required to give to their client before engaging in mediation. It's concise, it's eloquent, and I'd like to raise the possibility that this group adds that in to this as safe harbor language, essentially, for what a mediator might do to provide that extraordinarily short, extraordinarily accurate, and already adopted by the legislature description of confidentiality. So that's point one. And
Okay.
I'll stop there, but I have another point, but I'll wait for that one.
No, go ahead with your second.
Well, let me just finish that point then. That's already in law. It's in section 1129 of the evidence code, if anybody wants to look at it. And so it's already been adopted by the legislature as safe harbor language for lawyers with clients in mediation. I think it would be a good thing to add to these. My second point is, I don't know how we can adopt rules when we don't know what the law will be that may really greatly modify the confidentiality protections for mediation. And we won't know whether something is going to become law until after our last meeting is scheduled. So I find that perplexing.
Thank you. Anyone else?
Judge Pichon, did you want me to share the provision in evidence code section 1129 that
If
Mr.
it,
Kelly was referring to?
well, let me ask Mr. Kelly. Mr. Kelly, if it's law, why would we need to put it in the rule if it is the law?
Well, it's the law for an attorney to provide it to their client, but there's a fair number of unrepresented people in mediation who would not be provided with this unless they have representation by counsel. And I think it's a really excellent summary that this is a good place to put it into if we're talking about unrepresented parties.
Mr. Brown?
Yeah, thanks. First of all, thank you for the kind words, Mr. Kelly. I do think, though, that the current text of the document that would require providing a general explanation of the confidentiality of the mediation proceedings, I think that has the advantage of not being inconsistent with any new law that might be adopted, in this session or any future legislative session. If the bill that was discussed yesterday is enacted, that would become part of law and the explanation would be required. However, if that were to occur, then the statutory explanation in 1129 would become outdated. And so putting that in, sort of embodying that in the rules or elsewhere, would, I think, potentially create the problem that your second comment is in to address. Or maybe that was your first comment. I'm not sure which.
Thank you. I withdraw the suggestion. You're absolutely right. That may no longer be an accurate summary of California law. I apologize for taking the group's time.
No, please don't apologize. Fair point. All right, so we have standard 5 confidentiality, and I'm going to ask for a show of hands who, if it's fine, as if you support number 5 as written. All right, I see a majority.
Yes, I see a majority.
Okay. All right, thank you all. We'll move on to number 6. Number 6 is impartiality, conflicts of interest, disclosure, and withdrawal. And it appears, and you please correct me if I'm wrong, proposed State Bar Ethical Standard number 6, which is this one, is closely modeled after Rule 3.855 of the California Rules of Court. These are the comments that we received. And this is a summary. As I said, some of them were so long, I have to give you a summary. Several comments indicated that the tentative recommendation in Standard 6B1A that would explicitly require disclosure of past and current pending mediations for a party or participant is unclear concerning the necessary level of specificity. The next is, some also noted that mediators frequently mediate for the same lawyer, party, or participant, and that the proposed disclosure requirement would be burdensome. The last is, some suggest that mediators who mediate as part of a community mediation program or a court-referred mediation program should be exempt from the disclosure requirements. A provider organization commented that the disclosure requirements would, in some ways, surpass what is required in binding arbitrations. Would anyone like to make any changes um, based on this?
I see Mr. Palevsky's hand.
Zalewski?
No,
No?
I took it down.
Okay. Okay, so this is 6. Impartiality, conflicts of interest, disclosure, and withdrawal.
I
Judge
see Miss
Pishon,
Jenna.
I had a quick
Oh,
comment.
I'm sorry, who is that?
It's Jenna Ellis, sorry.
Oh, yes, Miss Alice, go ahead.
Sure. The one thing I wanted to just observe is that the appendices that we put out were very complex and
Mhm.
involved. And I felt that for the mediation tiers in particular, some of those tiers some of the proposed tiers touched on ethical issues, some of them related to this section, but they're not necessarily reflected in this section. And I just wanted to draw that to the group's attention and see if they had any thoughts. I was a little troubled by the idea of having some ethics standards hanging out in tiers and not all captured here, even some that I think were required at tier 1, just for purposes of any next public comment post Board of Trustee review.
Okay, thank you. Anyone else?
Miss Curtis has her hand, and Mr. Kelly.
Ms. Curtis?
Oh, you're muted.
Just in response to Miss Alice's observation, I was involved in both of those groups, the tiers and the mediation subgroup. And she's right that there are ethical obligations that would be undertaken in the levels, the tiers, that aren't part of this. So it's kind of an enhanced level of ethical observations or ethical obligation. Yeah, so that's really what I wanted to say. And Alan, you may have a more recollection of that than I do.
I see Mr. Kelly's hand, but let me just to follow for context. I believe what Miss Curtis has said is true. I'm not aware currently, and I haven't looked at the tiers and the group hasn't gotten to look at them. I'm not aware of any of the additional ethical requirements that are not in these standards that would be included in the baseline level of tiers. I'm not saying they don't exist. I haven't reviewed those, with this lens in mind, but I will say that when we develop the tier structure, we started with this document and tried to put what was required in this document in baseline. So, I mean, even a general requirement that the mediator adhere to this general set of standards. I think in higher tiers, there are perhaps higher obligations, but I don't know, Ms. Jenna Ellis, if you have specific instances of things that you're aware are set out in tiers and not in this document, that are required in tiers but not in this document. And apologies to Mr. Kelly, I probably should have deferred that comment.
I'm happy to let Mr. Kelly go first.
Mr. Kelly?
You're muted.
I'd like to have both of you finish that discussion because I have a different point.
Fair enough. So I just pulled up Appendix G, and I'm looking specifically at tier items 17 through 20. So 17, 18, and 20 are required at the baseline level. And for example, tier 20 states that during the pendency of a mediation, the practitioner notifies the parties and lawyers of any offer to accept a new professional relationship as an ADR practitioner with a party or a lawyer in the pending matter, and of any acceptance of any such offer in writing within 5 days of receiving and or accepting the offer. So that's probably the one that I think is the biggest difference. I haven't studied 18 as closely. I know 18 refers to like a time limit for disclosures going back, but those are just the few that were on my mind. Thank you.
So point well taken. And I just might suggest an approach, since we're not going to be looking at the tiers for mediators until after we look at the baseline for mediators, which is pending recommendations from the day of court subgroup. I think staff can make note of your comment, Ms. Ellis, and see if we try and flag any items like that before the tiers are discussed. And perhaps if those tiers criteria remain and they're not in this document, the working group might make a recommendation that they be added.
Thank you.
Thank you for pointing it out.
All right. Mr. Kelly and then Ms. Curtis. Oh, I'm sorry, Mr. Kelly, did you say that you are on another subject, or would you like to talk now?
Thank you. Well, Ms. Ellis just referred to the item that I was going to talk about, so I guess it's part of this discussion.
Okay.
The obligation to disclose has, for decades, been a real sore point with the high-end mediators that have maybe hundreds of pages of people they've worked with. And forgive me, but I don't see on the screen, and maybe it's there, a time limit for disclosure. Disclosure is a real sore point with a lot of high-end mediators, and if it's there, great. If it's not, then I think it would be important for the viability of this program to put one in. That was my comment. Thank you.
Okay. And Mr. Weiner, did you highlight, is that what's in red?
No, it's not.
Okay.
I believe that, and Ms. Curtis has her hand up, so she may have also something to say on this point. And I think, Mr. Kelly, if I'm understanding you correctly, you're suggesting that perhaps there should be something like this.
Tier 18 refers to the past 5 years.
Yeah.
Okay. All right. Ms. Curtis?
Yeah, Ellen, that might be best to go under number 1, but just above that. But I also wanted to say in answer to Ms. Ellis that number 2 mediator's duty to disclose is continuing and ongoing. And then number 3, well, not so much number 3 because that's new, but I think that that covers one of the concerns that you had, that, you know, in the course of a mediation, if there, you know, if you accept new business, that should be disclosed as well, if that's something that you've agreed to do. So, thank you.
Okay, and Ms. Curtis, you suggested that within the past 5 years go up above.
Right.
Okay,
A
where?
mediator must make reasonable efforts to keep informed about matters that reasonably could, you know, and then it covers all of the other provision.
Okay, so would it go after what word?
Um, matters within the past 5 years, the first line.
Oh, okay.
So if I may,
Yeah.
I see Mr. Yamshan's hand also. I would have a concern about adding it to that paragraph. I think that the point that Mr. Kelly was making was that it's the disclosure of the past business. If you make that disclosing matters within the past 5 years, there could, for example, be the existence of a grounds for disqualification of a judge that would be outside of the 5 year window, and that would, I think, inadvertently be limited. So I think if the concern is really about disclosing past and currently pending matter mediations, that it would really fit best in A. It's my 2 cents.
Oh, makes sense. Thank you, Alan.
All right, great. Mr. Yamshan, Mr. Palevsky.
Thank you. Here's my concern, is the AAA, ABA, and ACR standards of professional conduct for neutrals basically states that we should disclose anything that could create a perception of bias or lack of neutrality. If I have a law firm, for instance, that will be in a pending case, whether it's a mediation or an arbitration, and they've been before me 20 or 30 times and only 6 times in the last 5 years. So would that not be misleading to only disclose the last 5 years? I think if, with databases and so on, it's not hard to pull out how many contacts there are. I think Mr. Wiener's point is well taken. There's a distinction between contacts or affiliations of a personal or financial nature and of relationships as a neutral. Now, I don't pretend to have the appropriate language to make those distinctions, but I think it's important that we basically try to have our certified neutrals be as ethical as possible. I think that when the standards were promulgated, it was phenomenal how many years it took to get those into an acceptable form in the ADR community. I wish I could give you the language this afternoon, but I'm very concerned about these things. And I think that perhaps the reason that Ron states that some mediators may object to having a complete disclosure of this is with the potential for confidentiality issues. So if there is a certain party as opposed to counsel that has appeared before the neutral many times, and it's not unusual in arbitration for the same party to have appeared before me in 20 or 30 prior arbitrations, it's actually pretty common. Of course, everything's disclosed. The lawyers know who I am. They're free to recuse me and don't. But in the case of a mediator, it's every bit as important that the parties know that. So the time limitation is concerning to me. There may not be a way around it. Uh, I think that if we are reluctant to disclose, it says something about the integrity of the process itself. And basically, I'm reaching out to the group to come up with a reasonable solution for this.
Oh, thank you, Mr. Yamshan. Mr. Pileski?
You're silenced.
Yeah, I like disclosure a lot. I wanted to share some of the issues that arose in the arbitration context about disclosure because they're relevant here or they will be. One is record keeping. If to say you've got to go back 5 or more years, people may not have maintained their records or databases adequately to do that. As Mr. Yamshan said, many arbitrations are done specifically to be confidential from beginning to end, or even the fact of them. So there may be, it really matters what kind of information you're requiring to be disclosed. Is it just a number, or the parties, or the lawyers? And also, if it includes participants in addition to the parties, that may not be known until the mediation itself. And it's also not clear whether the attorney has to be disclosed or the entire law firm or anyone else in that law firm. So there's a lot that is required when you're, to specify when you're talking about disclosures.
Thank you, Mr. Pileski. Ms. Curtis?
No, that's okay.
Are you sure?
Well, I wanted to just, I guess in response to Mr. Pileski's point, in number 1, it says a mediator must make reasonable efforts to keep informed about the matters that reasonably could raise a question. And I mean, I think that, anyone who was participating in a court-connected program and understood these rules would have been keeping records. And there are some people that haven't done it and haven't been in the habit of disclosing. So, I'm not sure. I mean, I think going back and looking at the more enhanced ethical obligations in the tiers is a good idea, and perhaps taking this up then might make sense. But I think that the reason to add a 5-year limit is to allow that people maybe can't go back that far. That was at least the discussions that we had in the subgroup. And so putting a time limit on how far you have to keep, or when you have to start keeping records, which is going forward, and having an obligation to do what you can to discover and disclose past relationships are good. And then I do agree that we need to do something to clarify what the obligation is. That is it? You don't have to identify the name of the case. All you have to do is identify that you've had X number of cases before, and within the past, however recently. So those are some things that I do think needs some further work.
Okay, so Ms. Curtis, you're suggesting within the past 5 years, that language.
I'm saying that past 5 years relates to record keeping, and that it might be reasonable to, but it should sunset. I mean, we shouldn't forever have this obligation only to go back 5 years. And I hadn't thought about until Daniel mentioned it, that sometimes there could be years and 20 years of having lots of cases, and I think that matters. That a party ought to know. It may not matter to the party, but at least it's transparent.
Okay, thank you. Mr. Kelly?
I agree with Mr. Yamshan theoretically, and I personally do a written disclosure of everything that my records might show back as far as they can. But we're talking about something different, I think, here. The first clause says you have to disclose to everyone things that could reasonably raise a question. That's a subjective test. The next clause that we had was a specific test. You have to disclose these various different relationships. And that's the one we're talking about a 5-year limit for. We're not talking about limiting forever the ones that could reasonably raise a question. There's no limitation on that, at least as this is currently phrased. And there's no limitation on the existence of grounds for disqualification for a judge under 170.1, which has the same standard of reasonableness. So I think it's important for us to look at the fact that we're talking about two different things. One's a subjective judgment about what could reasonably raise a question. The other one is, I think, intended to be much clearer. You have to disclose any of these kinds of relationships, and I would suggest within the past 5 years is a reasonable one to be specific about. So these are two different standards, I think, and I think it's important to talk about them separately. Thank you.
Thank you. Mr. Yamshan?
Thank you. Regarding Ms. Curtis's issue, which is legitimate about record keeping, I think if the disclosures state the limitations of the records, that should be adequate. I know mine disclosed that I do not track witnesses in my database, for example. It states that I don't have access to records from a law firm that I started with in the early 70s that's now defunct, but it's in my disclosure that I can't do that. So it's an attempt to make full disclosure of that which cannot be disclosed. And I think that if the neutrals who, if you're smart enough to get certified, you're smart enough to write a disclosure statement. If the limitations of your database or your information knowledge is so limited, you can put that in your disclosure statement. And I have I like the idea of 5 years sunsetting at a very minimum, but I have some real hesitation about only going back 5 years for people who have been around a long time. Tier 3 neutrals are going to have a lot of experience and a lot of history.
Okay, thank you, Mr. Yamshan. Mr. Weiner, and I understand that people are probably ready for a break. But if you don't mind, if we just complete this one standard, then we can take a break. Mr. Weiner?
Thanks, Judge Bishon. So just while listening to the comments, I've tried to sort of parse out some of these paragraphs a little bit. I hope is my screen shared or no? Yes, it is.
Yes.
Okay. So, I mean, one of the things that seemed less questionable is currently pending. So I separated that out. I said mediations for a party or participant within, and here I've just been, as a placeholder, put at least the previous 5 years. I think to Mr. Yamshan's point, if you need to disclose anything that could reasonably raise a question, if somebody's done mediations for a party or participant for the last 25 years, that should probably be disclosed also. And I think that might be covered. And then so I've said other past, present, and currently expected interests. And this is all that could reasonably raise a question. So just approach for your consideration of separating the items out in that type of a fashion. I think the question about how much information to disclose, what do I need to say? Do I need to say the names? Is it enough to say, I've mediated for this party or this attorney five times before? I kind of think it might be best to leave that to the discretion of the mediator, what's the appropriate information to disclose under the circumstances, rather than prescribing specific information that does or doesn't need to be disclosed. But those are just my personal views.
Okay, thank you, Mr. Weiner. Ms. Curtis?
Yes, and I wanted to just thank you, Alan, and I wanted to highlight this word participant, because I think, as somebody mentioned, I think it was you, Daniel, and I don't think, or maybe it was Cliff, but I think that it would be better to just, leave it to party or attorney for a party. And somebody mentioned a carve out for community or day of court mediators, and we haven't talked about that. I think it's appropriate.
I see Mr. Polewski's hand. I just have one quick response, if I may, to Ms. Curtis's comment, and that is, if you limit it to party or attorney for the party in one industry, a common scenario is mediating with an adjuster, or perhaps mediating with it if they're expert witnesses, quote, expert witnesses in mediations like construction, defect litigation mediations. It may be important to include more than parties or participants.
Thank you, Mr. Weiner. Mr. Polewski?
Timing really matters. At what point do you need to make the disclosures? Before you agree to the mediation, before you spend your money up front, seems to be the rule in mediations. Before the mediation begins, I think if you're going to have that kind of disclosure, we should think through the timing.
I think at the earliest possible point.
Yeah, so.
And I think it varies.
Paragraph 2 does attempt to address this. Must be made as soon as practicable after the mediator becomes aware of a matter that must be disclosed. For example, if participants are included in the disclosure, it's possible the mediator may not know until participants show up in the mediation session. Again, I think this is derived from the rule of court, which I think has worked. I haven't heard.
Okay, Mr. Kelly?
In the one above that you added just recently, Mr. Weiner, I think 4 should be changed to with. I don't perceive myself, no, it's the one above. Oh, well, okay. I was thinking about A, but I don't think of myself as mediating for a participant. Thank you.
Would it be involving? Would that work better than with, or?
One way or the other, just 4 didn't work for me. I wouldn't know what it meant.
Okay. Anyone else? All right.
I see Mr. Welch's hand. Yes.
Okay, Mr. Welch?
Yeah, thank you. It's just confirming there's no written requirement for these disclosures, right? They can be verbal in this context. Is that correct? And that it was broad I know there's the day of hearing and community pieces that are within that we've discussed in the past, but as long as they're a broad disclosure, then it should be okay with that.
Question, if I may, Judge Bashan, just had the idea with respect to the concerns about what needs to be disclosed. Would it be helpful to say in the lead-in must appropriately disclose? Or does that just introduce more subjectivity and uncertainty? The intent was really to give latitude for the different circumstances that may exist.
Well, any comments on that? I did see a hand. Let me go.
Mr. Kelly?
Kelly?
Once again, I think, Mr. Weiner, it does just introduce even more uncertainty between the word reasonably and the word appropriately. I don't know how I, as a mediator, would really be able to figure out what this required of me. Thank you.
Okay, thank you. All right, there are many suggestions. Mr. Weiner has attempted to capture the substance of them. And so I'm going to ask the group, can you support? I think it's just subsection 1 as written. Can I see a show of hands of those who would support number 1 that you see on screen?
With the A, B, and C?
Yes, with the A, B, C, and the D. Okay, I see Mr. Kelly, Ms. Curtis, Mr. Tuckman, Dr. Getz, Mr. Welch. Oh, okay. Ms.
I also
Colton,
see,
Kopakin. Is that a majority that I see?
Yes,
Okay. All right. So
slight majority.
slight. Okay. So under 6, standard 6 is where we are. There was also a comment about just grammatical, where there's a little f. Should it be a capital F? And that would be under C and D. Or yes, those. Okay. Other than that, that's all I have for standard 6. And I know everybody needs a break. So
I,
we'll take
Judge Bichon, I'm so sorry. I see Mr. Kelly's hand.
Mr. Kelly.
I don't know if that's new or carryover.
Mr. Kelly.
I'm just concerned we have one plaintiff's attorney representative on this working group, and he didn't vote for this last one. And after the break, maybe I could understand why Mr. Polewski wasn't ready to approve that. I'd just like to hear his voice after the break. Thank you.
Okay. All right. Well, let's see what time it is. We'll break until 4:10. 4:10.
thanks, everyone.
We're recording, Chair.
Thank you. And Ms. Mia Ellis, I better make
Yes.
sure a few people left. Did I retain my quorum?
Yes, you still have a quorum.
Okay, great. All right, Mr. Kelly, you asked for if Mr. Tuckman would give you a short, very short explanation of his position.
That was Mr. Polewski. I
I'm
was
sorry, Mr.
interested.
I'm sorry, Mr. Polewski. If he
We,
very short, please.
I am a big fan of disclosure. My concerns were having dealt with the arbitrator disclosures and how they operate, and when the disclosures are made, and the duty to withdraw in E. I just think that I really want to help finish, so I'm gonna sort of shut up, because I gotta tell you, from the very beginning, I've been so impressed, and it has warmed my heart with how ethical the mediators on this panel are. And if they're willing to live with this, far be it from me. But I'm just trying to point out that, for instance, because mediation is very different than arbitration. In my mind, Ron mentioned I'm a plaintiff's lawyer. Neutrality matters to me a lot more in arbitration. Skill matters a lot more to me in mediation. It is very common for me to ask the other side to suggest a mediator, so that they have credibility in the other room. So not that neutrality isn't important, but it's a different equation. In order to get certain mediators, you're looking 3 or 4 months into the future, and they want the money up front. What happens when there's continuing obligations to disclose, and we have a rule that says upon a disclosure, the mediator must withdraw? What happens to the money? I'm not saying I oppose any of the concepts. I'm just saying that the rule, without fleshing out what should be disclosed, record keeping, and making it an ethical rule, is creating complications and traps. And I would prefer to have more time and have a rule that wouldn't be so overbearing with implications that would discourage people from becoming certified. So I completely support the concept. I just think it's not enough to say, well, disclose what you think is important, or however you want to disclose the past mediations. I just think that from experience, it's a very like even with the arbitrator disclosures, we have this continuing disclosures now, as you all know. And if you take additional cases, that in and of itself at this point is not enough to disqualify an arbitrator. And so timing, I think that it's just very complicated, and I was just not comfortable signing off without some of the questions I raised, but I'm not going to vote against it. And I don't mean to slow us down. I'm just trying to share my concerns with the ambiguities. That's all.
Thank you very much, Mr. Polewski. All right, we're going to now move on to Standard 7, which is competence. And there were no narrative comments to Standard 7. Stop me if you want me to stay there, but I'm going to suggest moving on to number 8. And number 8 is quality of mediation process. The comments included, first of all, this is not a comment, this is a statement. And you can correct me if I'm wrong, that tentative recommendations set forth in proposed State Bar Ethical Standard 8H is identical to Rule 3.857D of the California Rules of Court. So H is identical. The question asked by the working group when we asked for comment, invited the commenters to express their position and provide narrative comments on this provision, 8H. And the comments included concern that proposed standard 8H may be interpreted to limit a mediator's ability to prepare stipulated judgments as opposed to memoranda of understanding or deal memoranda. In family law practice, attorney mediators routinely prepare stipulated judgments from start to finish at the request of parties. This includes not only memorializing parties' agreements, but incorporating required statutory provisions such as child custody jurisdiction, child and spousal support requirements, and statutory advisements to ensure accuracy and enforceability. So that encompasses the comments, the written comments that were made. Would any member of the group like to make any changes to this particular standard, which is number 8, quality of mediation process? Okay, I believe I looked at everyone. All right. I see under H, the little d is now a capital D. Okay. Then we'll move on to standard 9, which is marketing. The responses are the following. This is summarized. 2 commented that family law matters involve mediations over months or years with multiple sessions, and that it is common for mediators and related professionals to work together across multiple matters simultaneously. 2 commenters said that. Other commenters noted that some mediators are on specialized lists or rely on repeat business, and that a prohibition such as the working group asked about would not be workable. Next, several of the commenters who opposed a prohibition on acceptance of the new business from a participant in a pending mediation also noted that this should be disclosed to and agreed to or waived by the other participants and should be consistent with the other ethical limitations. In the additional comments, question 12, a community mediation program commented that their mediators may suggest additional mediation sessions for parties on other issues that come up between the parties in the mediation and consider a separate mediation on an issue that is not included in their current mediation, such as in a court mediation program. The commenter notes that this information is provided as a service that is available to them at low or no cost, and that the mediators have no financial incentive associated with this. Would anyone like to make any changes on this standard number 9, marketing?
Sean, if I may.
Yes.
Yeah, I just wanted to point out that in the request for comments, the working group asked for comments on whether mediators should be prohibited from accepting as well as the additional business. I think some of the comments address that, and I think a question for the working group's consideration might be whether the working group wants to make a change to say must not solicit or accept. I think that would be what the request for comments, that would be the so I don't know whether the working group wants to address that question specifically, so we can it's probably something that should be handled. I see Ms. Coulter's and Mr. Kelly's hands.
Ms. Coulter.
Thank you, Judge Pichon. As a family law mediator, it's true. We work in a small group. And so as I'm reading this, I'm like, okay, but I don't need to solicit. Oh, now I can't solicit or accept new. That can create a problem when we all work together and refer cases to one another. So I might be willing to vote if it's a mediator must not solicit, but not if it's must not solicit or accept new business from a participant.
Okay, thank you, Ms. Coulter. Mr. Kelly?
I strongly oppose the addition of the or accept. There's lots of places where it's a small group, and like the family folks said, they might work together with consulting counsel over a period of several different sessions, and I think this is going too far. I even have a little hesitation. I'd never thought of it before, but day of court mediators who say, look, I think you might need another mediation on this session or this other aspect of it. Is that considered soliciting business to suggest another session next week or a new mediation on a related issue? Is that what's considered soliciting business? In which case, I'd like to really look at this more closely. Thank you.
Thank you. Let me see if there are any other hands. All right. Ms. Coulter has asked for the inclusion of the words, let's see, where is it? Or accept. And Mr. Kelly says he's strongly opposed to including the words or accept. I'll just ask, does anyone have a position on that? Mr. Weiner?
Yeah, if I could just interrupt, I think there may have been an audio failure, but I understood Ms. Coulter to oppose the addition of
solicit.
No, of adding or accept. So she was of the same mind as Mr. Kelly that the prohibition on accepting a new business should not be added. I would just observe, again, this standard I think was taken directly from the rules of court. I don't know that there have been questions about what solicitation means, but arguably to Mr. Kelly's point, I think that there's a question about what that means. I mean, in my view, suggesting that the parties have another session to resolve, open issues doesn't strike me as what the statute is or what the rule is, ethical rule is intending to prevent. I think what it's intended to prevent is the mediator saying, by the way, I'd love to have you bring me your other cases if you have any other cases that you think I could mediate effectively.
All right. Yes, I did not understand Mr. Kelly and Ms. Coulter to be saying the same thing, but I stand corrected. Okay. Any other comments? All right. Mr. Weiner, your hand's still up.
Oh, apologies.
Okay. All right. So I'm going to ask if, let's see, that would be all for number 9. May I have a show of hands of all who would approve standard number 9 as written? See Mr. Kelly, Ms. Coulter, Mr. Yamshan, Mr. Welch, Dr. Getz, Mr. Palevsky. Anybody else? I don't think that's a majority.
I think you have half.
I'm sorry.
You have half the people, half the
Okay.
members here supporting.
I think it was 6 indicating that they would support it and 5 not indicating that they would support it.
Okay. All right. Thank you. Then the straw
Or
poll.
maybe it's 6 and 6. I stand
Oh, is
corrected.
it 6 and 6? All right. Then should I enter the straw poll? Or ask if there are changes that someone wants to make?
Yeah, I would suggest seeing what the people who wouldn't support it in its current form would like to see revised, maybe, and what would gain their support.
Okay. All right. Those who would not support 9 as written, what would you like to see there?
Mr. Tuckman's hand is up.
Mr. Tuckman?
Yeah, to the extent it's helpful, I did not put my hand up, but I also wouldn't vote no.
Okay.
If that's the consensus of the group. I'm a little concerned about these issues about what solicitation really does mean, in the mediation context. I just have some concerns about easily tripping over some scenarios that could come up.
Okay.
That's the main reason I did not raise my hand. But
Thank you for that. Okay.
I
All
see
right,
Ms.
Ms.
Kopakins.
Ms. Kopackin?
Thank you. Judge Pichon, like Mr. Tuckman, I don't think I would vote no on it. There are 2 concerns I have. I think his concern is a good one. The other concern I have is that I don't really, I have lost the thread on exactly how this looks as compared to what is being proposed for the arbitrators. And I am mindful that, and I guess I can't remember what that is, and I have the sense that it may be less onerous. And so that troubles me at some level. I like consistency, like Miss Ellis and Miss Doherty, and I may be recalling that wrong. So I just, without that information in mind, I was hesitant to jump up. I was one of the ones who supported this. I am in favor of robust disclosures, but I also am very mindful that we want people to adopt these standards, and so I'm on the fence on it for those reasons.
Okay, I appreciate that. Thank you, Ms. Kopackin. All right. To the group, if you object to this process, let me know. But based on that and the straw vote, I am going to move on to number 10, which is compensation and gifts. There were no narrative comments except there was a question regarding would it be problematic to accept lunch or tickets to an event? That was all that was there. Okay. All right, then that takes us to standard 11. That is attendance sheet and agreement to disclosure. The highest level of disagreement with the proposed ethical standards pertain to the attendance sheet requirement proposed in this standard. 9 commenters expressed concerns that proposed standard 11 conflicts with mediation confidentiality. 6 commenters asserted that the attendance sheet requirement conflicts with and/or should not apply to coordinators. Other commenters stated that it is unclear whether the provision is intended to apply to all mediation-related communications, such as emails and telephone calls occurring between formal sessions, which would be burdensome in family law mediation practice where such communications are routine. One working group member submitted a comment noting that the tentative recommendations for certification of provider organizations require that they provide specified information on their website about the availability of the state bar procedures for addressing complaints about certified provider organizations and practitioners. This working group members suggests that practitioners should be similarly required to disclose the procedures for addressing complaints to participants, and that this can be done by expanding the disclosure requirements in Appendix D. Would the working group, any members like to make any changes? Okay,
Mr. Welch's hand is up.
Mr. Welch?
Yeah, hi. I was just, thank you, Judge Sean. I was just wanting to speak just from the day of hearing piece. I think this is one I brought up before, and I know this is a must request for all participants. It's just one of a practical piece, right? And I think it was one that maybe there could be discussion in our subgroup about this just a little bit further to see if there is a way to use maybe a case number or use some other type of identifier that could be easier than having all of the requests for every single participant for this name, address, email, and telephone, just because of the practicality of the timing and some other pieces around that, because I do understand that need and necessity to know who all is involved. But I think there's layers of in a investigation portion of that to be able to find some of that information. So I just wanted to have potentially a consideration of that, but I also understand I don't want to hold this up completely for just that purpose.
Thank you, Mr. Welch. Dr. Getz?
Yes, I don't know if I was the member who suggested about widening the disclosures, but I guess I don't see a reason why we would have uneven application of communicating to participants in the mediation what their complaint process may be. In other words, why would we have the firms have to disclose this and not have individual mediators have to disclose that? I guess I just don't understand. I think the way it developed in our group, but I could be corrected by any of you. I think this was done first, and we didn't get to that issue. And I think the firms came later and they included that issue, and then we just never went back and made it even. But again, if we have the firms making it available to the participants, what the process is, I don't know why we wouldn't have all mediators make available that process in some way. Thank you.
Thank you, Dr. Getz. Mr. Weiner?
Yeah, if I can just address that a little bit historically. Part of the concern, so the obligation for provider organizations to have that on that website came out of the provider organization subgroup. It was assumed that provider organizations would have websites, but it's possible that individual mediators may not have websites. So I think that's one reason for the disparity. Also, historically, going back to the development of the complaint procedures for court connected mediations, as Mr. Kelly will recall, there was very strong opposition to a proposed requirement that mediators disclose at the outset of a mediation or before the outset of a mediation that there's a procedure for addressing complaints about them. The feeling was that that was going to set the wrong tone for the mediation. So just a little bit of relevant history, I think.
Okay, thank you. Let's see if there are any other hands. Mr. Kelly.
I may be lost, but I thought we were talking about number 11, attendance sheet and agreement to disclosure. And there was a comment that I don't think had to do with this number 11.
Okay.
Will we be talking about number 11 at some point soon?
Oh, wait. Aren't we on number 11? Yes, we're on number 11. Attendance.
I thought so. Well, I just wanted to say that the reason, as I recall, for these two things both being under the same heading is that the attendance sheet was necessary, at least under the rules of court, for someone investigating a complaint to contact all the participants and say, do we have your permission to hear all this stuff? And if so, which parts of it do we have? There's a reason why these two are together. And it's a very crucial one until and unless the law changes, that an investigator have the ability to contact all participants. Currently, all participants' consent is necessary to admit or disclose mediation communications in any later non-criminal proceeding that the law governs. So I am strongly in favor of keeping this word for word. Thank you.
Thank you, Mr. Kelly. Mr. Pileski.
Well, you're muted.
Boy, I'm not used to muting myself. A question which transcends this one and many of the other previous discussions. Is an insurance company a participant if they don't actually attend the mediation? Because they're making the decisions in at least half or 3/4 of my mediations. And I don't know that they're covered by the definition of participant. I'm not sure that any disclosure obligations relate to them, and they are really the decision makers in many of the cases.
Mr. Weiner. Thank you, Mr. Pileski. Mr. Weiner.
Yeah, so first in response to Mr. Pilevsky's comment, I've hopefully displayed the definition of participant. I think the nuance may be raised by Mr. Pilevsky is if claims officer is not in the room, but they're calling the shots. Maybe they may not even be talking to the mediator, but counsel for the defendant may be, going out of the room and talking to the adjuster about, whether or not they would increase an offer, accept the demand, et cetera. I think that's not clear. I think it's pretty clear from the definition that if the adjuster is, in the room or participating by phone, I think pretty clear that they would be included in the definition.
But many of them actually choose the mediators or veto mediators. They're very involved in the selection process. And they often steer a lot of business. So a lot of the things we're talking about here, disclosures and appearances, I'm not sure how to resolve all that, but I was just curious.
Yeah. So hopefully that shed some light on it. I also wanted to respond to Mr. Kelly's comment about the reason for the requirement of the attendance sheet. I think a part of the reason was, as Mr. Kelly states, that, and he and I were both involved in drafting this rule of court. I think part of the reason is so that the mediation participants' consent to disclosure of mediation communications can be requested if it's deemed necessary. Another aspect of the complaint procedure within the courts and the premise for the complaint procedure in this group is adopted is that mediation communications can be disclosed in a confidential complaint procedure because they remain confidential, the so-called confidentiality bubble. To Mr. Dr. Getz' comment, and I see he has his hand up also. I think that Dr. Getz's comment about providing information about complaint procedures on a website was probably fell under the additional comments. So it wasn't specifically related to standard 11, but there was a question following in the thought exchange. There's a question after standard 11 that asked, do you have any other comments about Appendix D? And so I think that's where the comment about indicating complaint procedures on a website came in, and because it naturally fell at the end of 11.
Thank you. Thank you, Mr. Weiner. Dr. Getz?
Yeah, just a follow up from Mr. Weiner. So I guess my question is, if you do not have a mediation through a firm where you could locate on their website, presumably some guidance about how to complain about the mediation, how would a participant in a mediation know how to complain? Is there any obligation on the mediator to let them know somewhere else in our standards? And if not, is the state bar satisfied with that?
Yeah, I think part of the expectation is that certified mediators are going to want to say they're certified, and that their certification seal or the information about their certification status will point to the state bar website where there would be information about the complaint procedures. Miss Mia Ellis or Miss Doherty, is that consistent with your thought, or do you have other additional insights about that?
Yeah, I do anticipate that it will, the information, excuse me, about complaint procedures will be on our website, and who is certified and who it will be on there. I think it does raise a good point about in terms of consistency. I suppose the question is, do we want to require mediators to have certified mediators to have websites and then have that information on the website?
Dr. Getz?
Yeah, I don't want this confused over the mode of communication and how that's done. I mean, we don't have to require mediators to have a website. All we're asking is whether or not it's an appropriate disclosure to tell them about a process, however we decide that should be done. I recognize that it would be a big burden on the mediation community to require all mediators to have websites. So I'm not sure the mode of communication is as important as the principle of how is somebody really going to find out about their remedies in a mediation.
If I may, Judge Bashan?
Yes, Mr. Weiner?
Yeah, so I think, I would agree with the sentiment that there should be information available to mediation participants in mediations conducted by certified mediators, that there is a complaint process. The standard way that the ethics standards tell mediators what they need to inform the participants about is by saying at or before the first mediation session, the mediator shall provide the following information, whether it's information about self-determination or confidentiality or something else. The problem I see, and you could do something like that. There could be a provision, in disclosures that would require certified mediators to inform mediation participants about that at or before the outset of the mediation. Mediators could then, if they so chose, provide that if they have written agreements or written disclosures that they make before the agreement, they could provide it in that information. The problem I see is that if they don't provide it in that information, or if they don't provide that type of information before the mediation, the only time they could do it is during the first mediation session, and I'm still in somewhat of a state of trauma from the adverse reaction when that was suggested back in around 2005.
Dr. Getz?
Yeah, just to conclude some thoughts on this. Listen, if my colleagues that the firms are not bothered by this inequity. And if the state bar is not bothered by it at all, I'm going to withdraw this discussion because I don't know if we have to go on any further about it. But I just, I find it, if a consumer was sitting in the room with us today, I think they would find this interesting and maybe not be supportive of the direction we're going here. Because the whole idea behind the statute, well, I mean, it's the main part of the statute is the ethical code. There's supposed to be a complaint process, and there's a hole here about how anybody would find out about the complaint process. And leaving the option to the mediators, as you know, Alan, in MC3, we had a nicely written paragraph that we allowed the mediators to put in their agreement to mediate that certainly did not throw anybody off their kilter and did not quell the discussion. So, but again, if nobody else besides me finds this to be an issue, I'm okay.
Okay, let's see. Are there any other comments? No? All right. Yes.
Judge Pishon, Jenna
Yeah.
Ellis here. I could have sworn that in the rules for the program, this was somehow separately covered, but I don't know why that's nagging around in the back of my head. But otherwise, I'll just say, I think Dr. Getz raises a good point.
Okay, thank you, Ms. Ellis. Anyone else? All right, well, it is a little uncomfortable when points are raised. They're great points, and if they're not picked up on, then sorry, I just have to move on and ask the group their position. And so we are at the end. There's been no suggested changes to the language. So that takes us to the end of Appendix D. And so I am at the point where I have to ask the group for a show of hands whether you support the language of Appendix D as it has been amended. May I have a show of hands? Okay, I see Mr. Kelly, Ms. Coulter. Mr. Welch, I think did I see Mr. Tuckman?
Yamshan,
Mr. Yamshan?
Mr. Polewski.
Okay, I'm sorry, do I have a majority?
No. Well, wait. You have half.
Exactly half? Okay.
Yeah, yes.
Are there any other changes that can be made to get the support for Appendix D? If not, I guess I have to participate in the straw poll. No, this is not the straw poll. This is
I see excuse me, Judge Bichon. I see hands up. I don't know if those are suggestions or questions. Mr.
Okay.
Kelly, Mr. Polewski.
Mr. Kelly?
No.
No, I was voting in support of accepting.
Oh, okay.
Sorry.
Mr. Polewski, were you voting also? Because I'm going to take the vote again because I want to make sure we have the count accurate. Okay.
I voted for it, and I just didn't take my hand down.
Oh, okay. So may I have a show of hands of all who support adopting Appendix D and moving it on to the Board of Trustees? Okay, so staff will help me. I see Ms. Coulter, Mr. Yamshan, Mr. Kelly, Mr. Polewski, Mr. Tuckman.
Mr. Welch.
Mr. Welch, that's 6. Okay, I think we have 6 out of,
12.
okay,
Judge Sean,
yes.
if I may, I was just going to ask, Dr. Getz was not among the members who indicated that he would support it as written, and we were, just because we were last discussing the question about notification of complaint procedures, whether that's the deal breaker, if you will, for Dr. Getz, if you don't mind my asking,
I don't mind.
or whether there are other issues.
Yes, but I'll take the path that's been taken by my colleagues in the past. I wouldn't vote against it, so I just couldn't support it. But I wouldn't vote against it because it's apparently not something the state bar wants and not something anybody else feels really strongly about. But yes, it was about that not having some sort of disclosure to participants about the process that we spent a year and a half on. So that's bothersome to me.
Okay.
Judge
Yeah.
Pichon, could I suggest just a quick straw poll on whether people would support including something like what Dr. Getz is talking about with that disclosure of the complaint procedure?
That's fine. Let's hear from Mr. Kelly first. You're on mute. Okay.
Go,
No.
please go right ahead. I'm sorry. We need to move on.
Oh, okay. Okay. So, Mr. Weiner, what was your question to the group?
I was just wondering whether there are other folks who would agree with Dr. Getz that there should be a disclosure of the complaint procedure included in the ethical standards. And, if there is a majority, I mean, when you asked for comments on it, people didn't speak up or down. But I wonder if asked specifically whether there might be support for that.
I support it.
Okay, let me see a show of hands of those who would support it. 1, 2, 3, 4, 5. I see Mr. Kelly.
There's 6.
6. Okay.
Oh, no, 7. Sorry.
All right, then. We'll add Dr. Getz's position. We don't have the exact language.
We could try and write it on the fly.
Yeah.
I think the suggestion was that might be included under the disclosures. Was that what you were thinking, Dr. Getz?
Yeah, it's the only place I saw that would go.
So if it just went to the end of those.
Alan, I just noticed that in Schedule L, you've added a proposal that would require something like this. This was a staff proposal. I just was searching for it.
Ms. Ellis has a suggestion. What is that? It's
I think Mr. Pilevsky and I were finding the same language. So I just pasted what I found in the chat. But I can't recall from earlier this summer what the vote was on this proposed program rule.
okay. All right. Well, let me ask the group about the language that Mr. Weiner has proposed based on what Dr. Getz has stated. May I have, Mr. Kelly?
I think I've located the requirement for provider organizations and looks well phrased. Can I put that in the chat?
Certainly.
I have put the
If you already
text
have that, Mr. Weiner, then I don't need it, but I just
I'm not
looked.
sure whether it's the same text. What I've just put here is what Miss Jenna Ellis was kind enough to put in the chat.
Well, let me put in what I found and you can see what you think of it.
You can put that in chat.
That's a requirement that I found for provider organizations, and it might be valuable to have some consistency. That's from page 33 of Appendix C. It's under proposed qualification requirements for provider organizations.
Would you be so kind as to give me that paragraph reference again?
I just lost it. Anyway, that's
okay.
It's in the preliminary report and recommendations dated February 27th, 2026 on page 29. I can get there again. Oops, no, it's not. Hang on, it's 31, I think. Yeah. Okay, I can get you. It's on page 33 of that document, which is Appendix C. It is, boy, going all the way back. What is this? Okay. It's proposed rule J. It says maintain a website that, and then you go all the way down to III. That's where it comes from.
Okay, so there are three iterations here for possible consideration. The two existing ones, I'm not exactly sure where Miss Ellis obtained this from. Can you give us that document again?
It's from the proposed ADR certification program rules, rule 3.1128, but it was a proposed staff edition at the time of public comment. And I know we discussed it earlier this summer, but I can't recall.
I'm staring at it now. It's in Appendix L.
Also in L, yeah.
Yes, and I see that there was some modification to it. Looking at the document.
Thank you, Ms. Ellis. I don't think I have the most updated.
Yeah, this was.
Miss Mia Ellis, do you have that final version at hand that you could put in the chat?
I can.
And can you tell us whether that was ultimately adopted by the working group as revised? I can try and dig also, but.
Yeah, let me look. Let me put this in the chat first.
Yes, thank you.
Oh. I'm hoping that's coming out because it was.
Yes, I have it.
Okay. And then let me see if I can find the resolutions.
Good language.
You're all terrific at digging these out.
Madam Chair,
Yes, I'm sorry, Mr. Kelly. I should have acknowledged your hand. I was trying to allow them to find what they were looking for. But yes, go ahead, Mr. Kelly.
I don't know about anybody else, but I'm a little fried and I don't feel
Ah.
competent to try and decide between these. I wonder if it might be diplomatic to say, staff, do you think you could work on this and bring it back with what you think is a better version?
Um, we did that last night, and staff works really hard at that, and then we reject it. So, Mr. Kelly, if you could just hang on another minute or two,
I
and
can't.
let's see if we can come up with the words.
Let me make a suggestion, if I may, Judge Bashan.
Yes.
Since staff at least came up with this language, wordsmith this language, and it passed the proposal as, or passed muster at least as the staff proposal. Could we look at this and see that came out of the staff proposal for Appendix L, practitioners who are providing ADR services other than through a certified provider organization must provide information about where persons may submit a complaint to the state bar or to a professional organization approved by the state bar, that the practitioner has violated an applicable standard. Information must be provided on the practitioner's website with the practitioner's fee agreement or in writing at the outset of the ADR process.
Okay, so Mr. Weiner, would that take the place of what, G, H, and J?
Yes, and these were all, they shouldn't be lettered. These were not new paragraphs. These were just
Okay.
different paragraphs that Word wanted to letter.
Okay.
So
All
it
right.
would be, it would become G if approved.
Okay. So if you'll just scroll to that particular paragraph that you just read, and then I'll call on Ms. Copaken afterward. Okay. So this is the one that you just read to us?
Yes.
G.
Yes, Judge Bashan.
Okay. And then I'll ask the group if they can live with this, if this will be okay with them. But first I'll hear from Ms. Copaken.
Thank you, Judge Pishon. This language that Mr. Weiner proposed looks generally good, except for that it does not acknowledge that we addressed the complaints against neutrals who also participate in the court-connected mediations. And so I think that it would be confusing in that regard. It would be at odds with that. So it would need to be adjusted. I was going to make a suggestion secondly, unrelated to this. I was going to make a suggestion similar to what Mr. Kelly was making, more just so that I know that you would like us to vote on this. And I candidly, Judge Pichon, I'm sorry, but there are, when we're trying to vote on the entire Appendix D, I think I would need to look at the whole thing at this point. I'm not sure fully what I'd be voting on. We've gone through piece by piece, and sort of up and down, but that was not even that staff necessarily needs to do anything other than kind of circulate where we're at currently. And it is 5:03, so I don't know. That would be my second suggestion. The first one is, I think this is inconsistent with what we did with regard to the court complaint process. And secondly, my brain can't handle all of this auditory revisions and keep it all together. Sorry.
No, that's okay. That's all right. All right.
Could I just,
So,
if I may, just ask Ms. Copaken if just inserting to a professional organization, to the state bar, a court, or a professional organization, with that?
That would. Thank you, Mr. Weiner.
Thank you, Judge.
I think so.
I apologize for the interruption. Yeah,
yeah.
I understand. It doesn't address the time to digest it.
Yeah, I think it's the applicable court. I mean, because you want to just go randomly to a court. So we're on the right concept.
Okay. Mr. Weiner, do you mind keeping that G, and I don't think the rest is, just keeping G and then circulate it, just send us out appendix D, and then everybody can look at it overnight.
Yes.
Okay.
I'm assuming the vote on this wouldn't occur until the meeting on August 20th, and that's how we would begin that meeting. Is that
Well, Ms. Kopaken was absolutely correct. I would like for the group to vote tonight, but I don't think they want to. And that's fine because everybody wants to be fresh. So yes, that would be where we are, that we would vote on Appendix D on August 20th.
all right? It may not come out overnight tonight then, but it will
Oh, well
come out
then, oh,
well
well, then there's
before.
plenty time, plenty time.
Thank you.
Okay, all right. Well, thank you all very much. I know it's very difficult. We may have to ask you to meet again so that we can get through everything. So have a good and restful evening, and thanks for all that you've done today. And I'll see you again on August 20th. Thank you all.
Thanks, everyone.